If he can make it here, I'll give him the chance to make an opening statement at a convenient juncture. But in the meantime, the witnesses are ready, and I'm cleared to proceed, and so we will go forward. 2 weeks ago, in a speech to the American Law Institute, Chief Justice Roberts said he wanted to assure people he was committed to making certain that the Supreme Court would adhere to the highest standards of conduct. More important, the Chief Justice acknowledged the court has more to do, that justices are continuing to look at things they can do to give practical effect to that ethics commitment, and that he's confident that there are ways to do that, ways to do more. The Chief Justice is right that there are plenty of ways the court could fix its ethics problems. Bogus personal hospitality, obvious conflicts of interest, phony front group amici. These are all areas ripe for repair. As chairman of the subcommittee, I've pointed out these problems and offered up solutions more times than I can count. But still, we wait for the court to do something, anything, to show that it takes its ethics seriously. The American people are tired of waiting. A new poll released the same day as the Chief Justice's remarks shows that almost 60% of Americans disapprove of the way the Supreme Court is doing its job, and that Americans are more likely to think that the justice's honesty and ethical standards were low or very low. For an institution that depends on the public's faith to carry out its functions, that is unsettling territory. If the Supreme Court isn't going to do anything to restore the public's trust, then it's up to us in Congress. Today, we're going to talk about real solutions to real ethics problems, the Supreme Court Ethics Recusal and Transparency Act. This committee has covered at past hearings how the bill would address problems like Justice Thomas's failure to disclose gifts and travel from a billionaire Republican donor. We've also discussed how my bill would create a transparent process for enforcing ethics rules at the court. Today's hearing will focus on how this bill would address recusals and conflicts of interest. From the very first days of this republic, Congress has regulated judicial conflicts of interest to help preserve the judiciary's integrity. Recusal and conflicts laws on the books expressly apply to the Supreme Court. It's time for Congress to step back in to fortify the administration of these laws. Case in point, for more than a year now, Justice Thomas has refused to recuse from cases involving January 6 or the 2020 election. In the first instance, Justice Thomas voted to stop the January 6 committee from getting access to White House communications that may have included Justice Thomas's wife's texts to the White House Chief of Staff about overturning the 2020 election. The lawfulness of that failure to recuse depends on a fact. What did Justice Thomas know about his wife's insurrection activities, and when did he know it? After more than a year, Justice Thomas has still never been obliged to answer that question. We don't know the answer to that essential fact. In no other court would such an essential question of fact go unanswered. Questions of recusal and conflict of interest are intertwined. So we need to know more about front groups that helped appoint Trump's justices and then appear as litigants before those same justices. And recent reporting shows ties among right-wing operative Leonard Leo, billionaire megadonor Harlan Crow, and Justice Thomas, again often implicated in the filing of amicus briefs without links disclosed. To these concerns and others, the response of the court has been secrecy and silence. My bill would end the practice of Supreme Court justices judging their own conflicts of interest, require better disclosure and transparency so the public knows when a justice has a connection to a party or amicus before the court, and require judges to explain their recusal decisions for everyone to see. As we hear from today's witnesses about why these reforms are needed, we should all keep in mind a maxim so old that it is in Latin: Nemo judex in sua causa. No one should be a judge in their own case. With that, without Senator Kennedy here, I won't yield to him for his opening remarks, but the chairman of the Senate Judiciary Committee, Senator Durbin, is here, and I would invite him to make any opening remarks he should care to deliver. Thank you for being here, Mr. Chairman.
Thanks to you, as chairman of the court subcommittee, Senator Whitehouse, for holding this important hearing today. I want to thank the witnesses for their participation as well. This is the third hearing we've had this year on the topic of judicial ethics. We're serious about finding real solutions to the ethical shortcomings at the Supreme Court. It was February 2012, when I first sent a letter to Chief Justice Roberts calling for the court to step up and adopt an enforceable code of ethical conduct. I've been pushing for this reform for more than a decade. It is long overdue. We need to restore public confidence and trust in our Supreme Court. That cannot be done when they operate in the dark and in secrecy. Today's hearing will discuss recusal transparency. We've seen interesting movement on this issue in the Supreme Court with at least one justice, Justice Elena Kagan. She's now providing public explanations for her recusal decision. She gets it. She understands that when the American people understand her thought process, it lends credibility to her final result. And the same thing's true for the rest of the court. The obvious question is, will another justice follow suit, Justice Kagan? Will Chief Justice Roberts step in to ensure other justices do so for transparency's sake? I've said before, and it bears repeating, the problem of ethics and disclosure in the Supreme Court can be cured before the end of the day by one person. Chief Justice Roberts of the Roberts Court, as it will go down in history, has the authority and the opportunity to step in and get this done now, rather than let this problem linger and even get worse with the conduct of some of the justices. He can do it, and he should. This committee will continue to pursue this issue because it is critically important to our responsibility under the Constitution when it comes to the Supreme Court. Now, a few weeks ago, Chief Justice Roberts gave a speech where he said, and I quote, "He's committed to making certain that we as a court adhere to the highest standards of conduct." I couldn't believe it. I thought he spoke up. Maybe he's finally going to do something about this. Well, he should do something, and he should do it now. Take the steps before the Supreme Court takes its summer recess to carry out the commitment he made in that speech. Let's not have another summer of justices jetting off for luxury junkets under an inadequate set of ethics rules. I've said it before, it's worth repeating. The highest court in the land shouldn't have the lowest ethical standards. If the court won't act, Congress must. Thank you, Chairman.
Thank you very much, Chairman Durbin. I will now introduce the witnesses and turn to them each after the introductions for 5-minute opening statements. If your written testimony is longer than that, it will be made a matter of record, but I'd urge you to confine yourself to the 5-minute time window so that we can proceed to the questioning part of the hearing. First, Donald Sherman is the Senior Vice President and General Counsel at Citizens for Responsibility and Ethics in Washington. Mr. Sherman oversees CREW's legal efforts to improve transparency and accountability within the federal government, including through ethics reform. Mr. Sherman previously served as counsel for the House Ethics Committee and has held several roles in Congress and the executive branch, including Chief Oversight Counsel on the House Committee on Oversight and Government Reform, Senior Counsel on the Senate Homeland Security and Government Affairs Committee, and Chief of Staff and Senior Counsel for Oversight and Investigations in the Department of Housing and Urban Development's Office of General Counsel. Professor Jennifer Mascott is an assistant professor of law at the Antonin Scalia Law School of George Mason University and the co-director of the C. Borden Gray Center for the Study of the Administrative State. Professor Mascott writes and teaches in the areas of constitutional law, administrative law, the separation of powers, and federal courts. Professor Mascott previously served as an associate Deputy Attorney General in the U.S. Justice Department and as Deputy Assistant Attorney General within the Department's Office of Legal Counsel during the Trump administration. Professor Mascott also clerked for Justice Clarence Thomas, and before that, then Judge Brett Kavanaugh. Professor James Sample is a professor of law at the Maurice A. Dean School of Law at Hofstra University. Professor Sample is an expert on the law of judicial recusal, judicial elections, and the intersection of campaign finance and judicial ethics. He is the co-author of a leading text on judicial ethics and has written numerous articles on the history of and issues related to judicial recusal. Professor Sample previously served as an attorney in the democracy program at the Brennan Center for Justice at New York University School of Law. He also clerked for Judge Sidney Thomas on the U.S. Court of Appeals for the Ninth Circuit. We welcome all of you. Mr. Sherman, you may proceed.
Chairman Whitehouse, Ranking Member Kennedy, and members of the subcommittee, thank you for the opportunity to testify before you today about the Supreme Court Ethics, Recusal, and Transparency Act and the urgent need for a clear, transparent, and binding recusal regime for the Supreme Court. I am here representing Citizens for Responsibility and Ethics in Washington, a nonpartisan, nonprofit organization devoted to ensuring the integrity of our government institutions. Today, there is a crisis of confidence in our federal judiciary. This crisis is the result of a number of overlapping failures, but chief among them is the judiciary's apparent inability to abide by the rules of ethical conduct their high office demands. As the Wall Street Journal reported in 2021, over a 9-year period, more than 130 federal judges presided over 650 cases in which they had a material financial interest in one of the parties. More recently, the public has learned of unreported gifts accepted by Justice Clarence Thomas from a billionaire political benefactor, and of a decades-long campaign by wealthy activists to purchase unparalleled access to the Supreme Court. Sadly, these scandals were entirely preventable. For decades, liberal and conservative justices alike have tested the limits of this lax ethical regime, while activists and advocates, regardless of ideology, have exploited every gap they can find. Like many Americans, I have long regarded the federal judiciary with great reverence and even awe. I recall fondly every fleeting interaction I have had with the High Court, from attending my first oral argument to visiting chambers and touring the highest court in the land. Even after years of ethics problems facing the judiciary, many organizations, including my own, were hesitant to sound the alarm because we often litigate in the federal courts. That reluctance, combined with the benign neglect of many in Congress, have also contributed to the current crisis. Unfortunately, our collective reverence for the court has resulted in giving undue deference to the 9 justices for their ethical compliance. The Wall Street Journal's reporting and recent revelations of ethical issues impacting justices across the ideological spectrum have made the case for reform undeniable. The CERT Act takes a number of actions to respond to this crisis, each of which will promote the independence of and rebuild public confidence in the judiciary. In particular, the CERT Act would reshape the Supreme Court's recusal regime in a constitutionally appropriate manner, adding transparency and accountability to an opaque and broken system. The CERT Act's enhanced recusal provisions would create a more robust process for identifying and deciding recusals to ensure the justices' independence in their work on behalf of the public. After all, they are government employees. This is my 3rd time testifying before Congress about judicial ethics, and I want to proactively address some of the questions that I have heard before and expect to hear today. First, the need for ethics reform at the Supreme Court is not a partisan issue. I've been an ethics lawyer for more than a decade, but you don't need to be an expert to appreciate what's wrong with judges ruling on cases where they have conflicts of interest or with making their own recusal decisions. Second, I have also been Black in America my entire life. I am absolutely certain that Justice Thomas has faced racism in his. I am also absolutely certain that bolstering ethics rules that will apply to every justice, regardless of ideology, is not racist. The idea that these necessary reforms are political or retaliatory is equally absurd. While we cannot dismiss Justice Thomas's egregious ethical problems, it is also true that former Justices Ginsburg, Breyer, and others have heard cases where they likely should have recused. Even more troubling, every single one of the current justices has rebuffed basic oversight and reform, arguing that we should just trust them to make their own recusal decisions, despite years of scandal at the court. So while it is regrettable that some politicians have directed incendiary rhetoric at justices they oppose, one cannot acknowledge the ethical blunders by both liberal and conservative justices in recent years and credibly defend this untenable status quo. In closing, despite having the power of judicial review and enjoying life tenure, federal judges have substantially fewer ethical checks than their counterparts in the legislative and executive branches. And the highest court in the land has the lowest standards regarding conflicts and recusals. It is now abundantly clear that the justices cannot or will not effectively regulate themselves. Your favorite liberal icon and your favorite conservative hero on the court need binding ethics rules that include a transparent and independent recusal process. The CERT Act does just that. Thank you for the opportunity to testify on this important topic. I look forward to your questions.
Thank you very much, Mr. Sherman. We now turn to Professor Mascott.
Chairman Whitehouse, Ranking Member Kennedy, members of the subcommittee, thank you for having me here to testify today. I'm Jennifer Mascott, a professor at Scalia Law School, but I'm testifying in my individual academic capacity, and so my views obviously don't reflect the views of my academic institution. I was last here before this committee about 12 months ago, right after the leak of the Dobbs opinion, when we were at that point going to discuss Chairman Whitehouse's legislation, but the discussion took a little different turn. And sadly, personally, since that time, my husband unexpectedly fell ill with pancreatic cancer and passed away just a few weeks ago in February. So I'm glad today to have the opportunity to be back before you.
We welcome you back.
After that circumstance. Thank you. So today I've been asked to talk a little bit about any separation of powers questions that might arise in looking at regulation of procedure with the Supreme Court. Congress obviously has a very important constitutional role to play related to the federal judiciary. Congress is responsible obviously for establishing inferior federal tribunals, and since the Judiciary Act of 1789 has taken significant action to regulate and address the procedure and subject matter jurisdiction of federal courts, including the Supreme Court. But Congress's power in this area with the federal judiciary is pegged to its authority to establish inferior tribunals, and also its necessary and proper power to enact laws to carry into execution the vesting of federal judicial power in the Supreme Court and other federal tribunals. And so it's not an unbounded authority necessarily to regulate all actions of various judges and justices. And since 1789, this body has had a practice of leaving the courts with significant discretion in regulating procedure and also administration of their own affairs. Two additional principles in the constitutional structure that I think are relevant to the discussion today include the concept of the Supreme Court sitting over inferior tribunals, the concept of a hierarchical system within Article 3, and then also the more constrained role of the judiciary to resolve discrete cases and controversies, in contrast to this body and the executive, which are elected by the American people. And so I think those principles come up and touch on several aspects of the draft legislation. First, the legislation has some provisions in it providing for notice and comment procedures when the Supreme Court looks at its own procedural mechanisms and recusal rules and ethical codes. And so in contrast to this body and the executive branch, where the public, through the electoral process and commenting, has a much more direct role in procedures, the Supreme Court and the federal judiciary, by the terms of the Constitution and the constitutional structure, were set aside to be impartial, as the title of this hearing reflects, and judges given tenure protection and salary protection so that they would not be too swayed by the public. And so I think it's important to think through whether there is tension between having having the public comment on ethical codes of the Supreme Court, which we want to stand apart from political considerations and mores. In addition, aspects of the draft bill enable individual members of the public, even apparently in situations where they don't necessarily have a case before the Supreme Court, to raise individual ethics complaints and try to initiate investigation into various aspects of judicial or Supreme Court affairs or recusal decisions that also may create tension with the notion of an impartial judiciary that's set aside from the political process. And then finally, aspects of the bill that give lower court judges a role in overseeing or approving of various justices' decisions, whether to recuse or how to handle their role in a particular case, also may set in tension with the constitutional structure. As a policy matter, too, I think it's good to think about whether it makes sense at this point to significantly increase regulation of the judiciary, which by many metrics I would argue is actually working quite well. President Biden at the start of his administration established a commission to review and look at the Supreme Court and courts in general and its structure and how it's operating, and that commission did not coalesce around a single significant change that needs to be made. Close to 40%, more than 35% of decisions or judgments each year over the past 10 years issued by the Supreme Court are unanimous, and Congress has many tools at its disposal to regulate practice of courts through subject matter jurisdiction and other procedures that have a much more long-standing historical provenance than some of the disclosure and recusal provisions in this particular bill. Thank you. I look forward to discussing this further and answering questions.
I think you just set the subcommittee record for the most amount of testimony in 5 minutes. Well done and congratulations. Professor Sample.
Chairman Whitehouse, Ranking Member Kennedy, and members of the subcommittee, thank you for inviting me to testify today. In our polarized political era, the tendency is to see nearly every issue through a partisan lens. Viewing robust judicial ethics rules as partisan, however, is reductive at best and corrosive at worst. The acute problems we face are not limited to jurists of any particular ideological stripe. As my written submission notes, on the Supreme Court, legitimate concerns can and have been raised as to jurists across the ideological spectrum. As Erwin Chemerinsky powerfully wrote in the New York Times just 2 days ago, liberals and conservatives should want a Supreme Court that is above reproach. Yes, there is variance in the severity and regularity of the problems surrounding individual judges and justices. But fundamentally, and with extraordinarily rare exception, the problem is not the people. Though iconic figures, Supreme Court justices are human beings. They make mistakes. The problem, with only rare exception, is not the people, but the system. So what is the central flaw? Well, Section 455A of Chapter 28 of the United States Code states that any justice or judge of the United States shall disqualify himself or herself in any proceeding in which the judge's impartiality, and now we get to the key phrase, might reasonably be questioned. The standard is, by its terms, objective. Indeed, if anything, it layers an excess of caution on top of the objectivity by emphasizing that disqualification is required whenever the judge's impartiality might reasonably be questioned. Yet that objective standard is combined with a nettlesome tension, even a contradiction. It is applied entirely subjectively by the judge or justice in his or her own case. It should come as no surprise that the results of such a system are inconsistent. In analogous circumstances, some justices recuse while others do not. Section 5 of the proposed legislation would require jurists presented with a recusal motion to either recuse or have the question referred to an impartial panel of randomly selected judges. In the case of the Supreme Court, the panel consists of the other justices of the Supreme Court. The proposed legislation before you is not top-down congressional control of granular details in a co-equal branch. On the contrary, Section 2 of the legislation merely requires the Supreme Court to issue a code of conduct for itself within 180 days. And doing so would merely level up the Supreme Court so as to bring the highest court in the land more in line with the stronger standards applicable in all lower courts. Chairman Durbin's opening statement made this point more eloquently and certainly more powerfully than I ever could. Similarly, Section 3 of the legislation mandates that justices disclose the same information concerning gifts, income, and reimbursement as required of members of Congress and members of the executive branch. The current system, particularly because of the lack of enforcement in the Supreme Court, means that egregious failures to comply with existing federal law recur and recur without meaningful consequence. Consider as a rhetorical question whether it makes any sense to require less of the branch where impartiality is the touchstone than we require of the two constituent branches. I applaud the legislation before the committee and the sustained efforts to bring us to this day. The Supreme Court Ethics, Recusal, and Transparency Act would protect litigants, promote public confidence in the judiciary, and do so without jeopardizing the court's decisional core independence. The legislation is necessary, measured, and constitutional. Thank you.
Thank you very much, Professor. For the benefit of my colleagues, the order that I have is Whitehouse, Durbin, Blumenthal, Hirono, Welch. And without objection, I would like to add to the testimony a statement for the record prepared by Professor Charles G. Jay of the Indiana University Moore School of Law, and a statement of the Project on Government Oversight. Professor Sample, let me turn to you. Federal law currently contains a provision, 28 United States Code, Section 455, that governs when judges should recuse themselves from a case in which there is a conflict of interest. Can you explain generally what that law requires?
Yes, Mr. Chairman. Section 455 is the language that I quoted a moment ago that says that a judge shall recuse, and it uses the language shall, which is mandatory language, in contrast to some of the remarks that the committee has received from the Chief Justice and others that make the standard sound as though it is merely aspirational and subject to voluntary compliance. It says whenever the judge or justice's impartiality might reasonably be questioned, the judge is required to recuse him or herself. The practice in many lower courts and in many state courts is to have those decisions reviewed, but at the Federal Court of Appeals level, there isn't a procedure to do that, and at the Supreme Court level, there is absolutely no procedure to do that, and what happens is that we have unreviewable decisions by the individuals who are acting as the judge in essence, as you put it in your opening statement, their own case.
That law applies to Supreme Court justices?
Yes, it does.
And obviously, Congress passed that law.
Correct.
Has the Supreme Court ever ruled that this law or any other recusal law, or for that matter, the Ethics in Government Act, was unconstitutional or that it can't apply to the justices?
No, the Supreme Court has never ruled in that manner.
Indeed, have justices not complied with it?
Most of the time, they have complied with it.
Without objection?
Without objection.
Let me turn to Mr. Sherman with an example. This relates to disclosure and when conflicts of interest should be presented to the parties and the public so that an informed recusal conversation can transpire. In 2020, the right-wing flagship political organization of the Koch brothers, Americans for Prosperity, spent at least $1 million on what it called a full-scale campaign to confirm Judge Amy Coney Barrett. including hundreds of thousands of phone calls and emails, ads, op-eds, and a website called uniteforbarrett.com. Americans for Prosperity had run similar campaigns, spending millions for all the Trump justices. At the same time, there was a case pending before the Supreme Court that was brought by the virtual alter ego of Americans for Prosperity. This organization was called Americans for Prosperity Foundation. For those of you who are not familiar with the state of the art in dark money political influence tactics in America, the latest and greatest is to set up a 501c3 and a 501c4 that are effective twins, that have the same donors, the same staff, the same address. They're indistinguishable. And this is the relationship between Americans for Prosperity and Americans for Prosperity Foundation. They share officers, directors, an address, and virtually certainly donors, although because of dark money protections, they don't disclose. What sort of disclosures should have been made to the parties in the Americans for Prosperity Foundation case about that relationship in order for people to make a determination as to whether there was a conflict of interest in one corporate entity appearing before the court of a twinned corporate entity that had spent millions of dollars to get those justices onto the court who were hearing the case?
Under existing law?
In terms of what the proper course of justice would suggest, let's put it that way.
Certainly. I think given the scenario that you described, it certainly it raises concerns about the opacity of the arrangement and whether this organization is using its funds to influence the justice. And disclosure would be advisable, but obviously isn't required under existing law, but would be under the CERT Act.
Yeah. Here's another one. An amicus showed up under the fictitious name, the Honest Elections Project. That fictitious name organization bears a relationship of virtual corporate identity to the Judicial Crisis Network, which, like Americans for Prosperity, spent millions of dollars in dark money to push for the confirmations of the Trump nominees. And they're coordinated by an individual named Leonard Leo, who has been deeply involved in the selection of at least 4 of the Supreme Court justices. There was no disclosure made of any of those relationships in the Honest Elections Project amicus brief. Why is that wrong?
Again, I think the public is certainly entitled to information about who is mounting privately funded campaigns to influence both who sits on the court and then what decisions they make when they're on it. But under existing law, they're not required to do so. But certainly under the CERT Act, there would be more disclosure required of amici.
Chairman Durbin.
Thanks, Senator. Mr. Sherman, when I heard them describe your background, it involves some work on Capitol Hill, did it not, with the House Ethics Committee?
Correct.
So let me give you a hypothetical and see if you can help me get to a conclusion. Let's assume that, like the Supreme Court justices, our congressional recess starts somewhere in August, and a really good friend of mine of many years decides that he wants to pay for my wife and myself to first fly on his charter plane to a distant destination and then spend a week or 2 on a very palatial yacht of his. And then he'll return me home after I've had my vacation. What kind of responsibility do I have as a member of Congress to disclose any of that?
Well, I think the first requirement you would have is to call the committee to seek approval to accept the travel in the first place. But then you would have to disclose the travel itself, if you were approved, the travel itself, the amount of the travel, and the source of the and who funded aspects of the travel.
When you say disclosed, do you mean publicly disclosed?
Correct.
So let me ask you if you know what rule would apply to a district court judge, a federal court judge, who had the same opportunity.
In the federal courts, my understanding is that there is less disclosure requirement with respect to privately funded travel. And at the Supreme Court, the personal hospitality exception would cover a lot of this depending on the nature of the friendship, and it wouldn't have to be disclosed at all.
So there'd be no disclosure in the district court level or the circuit court judges?
I believe there would be.
There would be disclosure.
Yes.
And they have a code of ethics as well?
Yes, they have a pretty lengthy binding code of ethics. The Supreme Court does not, though they say that they sometimes reference the former.
So Justice Thomas, when he did not disclose at the Supreme Court level, was he in violation of any law that you think applies?
Yes, so with respect to Justice Thomas, while personal hospitality need not be disclosed, there is a requirement if you're staying in somebody's home, for example, you share a meal in their home, but the payment of his actual travel to the location on the private jet, his travel on the boats, especially because that travel, as we understand it, was funded by a private company and not actually the hospitality of Mr. Crow, needed to be disclosed and was a violation of federal law.
Professor Sample, I'm trying to wrestle with the argument we hear from the other side that this separation of powers gives Congress little or no authority over this court created by the Constitution, as opposed to the inferior courts. And yet, when you made reference to 28 U.S.C. 455, this was one of the federal statutes enacted by Congress to apply to the Supreme Court, which apparently the court at least nominally follows. Is that correct?
Correct.
Can you rationalize that thinking that Congress has no authority over the court, and yet the court follows what Congress says it should?
I think, Senator, it's clear that Congress does have authority to regulate the Supreme Court. Indeed, separation of powers doesn't mean that one branch of government is entirely independent of the others. Congress regulates many aspects of the Supreme Court, including the size of the court, the salary of the justices, its budget, the quorum requirements. As far back as the Judiciary Act of 1789, Congress has been in the business of making manifest the Article 3 promise that there will be a Supreme Court, but without Article 1 legislation that this Congress can pass, that Article 3 promise would be a parchment promise at best.
I'm sure I'm not saying this as they would, but those on the other side argue that Congress has authority when it comes to those elements you've just mentioned, but doesn't have the authority to impact the decision-making of the court. They draw that line. Do you recognize that same distinction?
I think, and in the prior hearing, Professor Amanda Frost did a nice job, in my view, and her written testimony does a nice job laying out that the key core of the judicial process is the power to decide cases and controversies. And so a decision that intrudes on the core decisional independence, in the case of Smith v. Jones, say if Congress were to say that Smith has to win and Jones has to lose, that's a real problem. That's an intrusion into the core of the judicial power. The legislation that you and your colleagues have proposed does not intrude into that core decisional independence in any way.
Thank you. Senator Rono?
What would we do without our staff to tell us what's what? Well, welcome everybody. I think this is a very important issue because when we talk about the need for the public to hold the court, especially the Supreme Court, in high regard, you know, in spite of the fact that there's very little we can do if the Supreme Court is doing things that we don't agree with, but why, you know, I'm just curious, especially maybe for Professor Sample, why is it important that the public hold the Supreme Court in high regard?
It's a very good question, Senator, and I think that the answer is that democracy is fragile. It depends on faith, trust, and goodwill, and it depends on confidence. You know, famously, the court lacks the power of the purse, and it lacks the power of the sword. It depends on people believing in its legitimacy for its rulings to be respected and followed in a manner that is that is consistent with civilized society.
Would you agree, Mr. Sherman?
I would. I would also say that the courts exist so that there is a neutral arbiter to resolve disputes between individuals and institutions. And if people don't have faith that the courts are a neutral arbiter, then they won't avail themselves of the courts, which is also a problem for democracy.
I think availing themselves of the courts, if they do not have confidence in the objectivity and fairness of the courts, I think that is a real concern. Now, I think we made it plain that the Congress does have the power and the authority to shape the size, determine the size of the Supreme Court. It holds the power of the purse over the Supreme Court. It can require justices to ride circuit, for example. So I would like to ask all three of you, does Congress have the power to enact the CERT Act? Mr. Sherman?
Yes.
Professor, Mascott. Do we have the power to enact the CERT Act?
Well, without getting into all of the details of the act, I think the questions that I raised in my earlier statement about the particular bill here are who is involved in enforcing some of the rules and requirements that are put into place. So, for example, putting lower court judges.
But we do have the power. There may be some concerns about how things will be implemented or how, those kinds of concerns. But my question is simple. Do we have the power to enact the CERT Act? I would say probably yes. Professor?
Yes.
Oh, okay. One of the things that you testified to, Mr. Sherman, really caught my attention when you referred to the Wall Street Journal's 2021 report, wherein 130 federal judges presided over more than 650 cases in which they had a material financial interest. I'd like to know, how did this come to light that this kind of conflict existed in these instances?
Well, as I understand it, the Wall Street Journal spent a lot of time mining through an archaic system of financial disclosures and identifying specific holdings that judges had and the cases that were involved. In many cases, the judges claimed that they didn't know. This was one of the reasons why Congress last year passed legislation to update and automate that process.
So are you saying that, not having read that article, that out of these instances that there was not a lot of recusal from these judges as they made decisions regarding these cases in which they had a conflict?
Correct.
So, Professor Sample, do you think that the CERT Act will remedy this kind of circumstance where the judges are not paying enough attention to where they have financial conflicts, which is probably the simplest conflict to ascertain and thereby leading to their recusal?
I think that the CERT Act will do a large part of the work to at least mitigate that problem. We may still have remnants of the problem, but the CERT Act would do yeoman's work to prevent that kind of a scenario, requiring judges to recuse themselves, or if they decline to do so, to have those decisions reviewed by their peers. The reality, and the Wall Street Journal did a tremendous job in reporting that piece, and I think it shows one of the fundamental flaws, which is that we are combining a system in which the judges are already going to be the judges in their own case, and that is only really a case if they've done the legwork in advance to determine via fact-finding that there might actually be a direct pecuniary interest on their part, and that's a real problem.
Mr. Chairman, if I may, I think the pecuniary interest is really the most objective way that you can define a conflict, but I would say there are also relational conflicts And so there may not be a pecuniary interest, but if you're married to somebody who's taking a position that is being challenged in court, that is a relational conflict. And I just want to mention, I am very familiar with a case that involved the state of Hawaii, and a major act that was being challenged. It was called the Land Reform Act. It went all the way 10 years, all the way to the U.S. Supreme Court, and Justice Marshall recused himself because he was married to a person who was born in Hawaii. That is a relational perceived conflict. Thank you, Mr. Chairman.
Senator Blumenthal.
Thank you, Mr. Chairman. Whenever these issues of ethics are discussed, I can't help but thinking back to my days as a law clerk for Justice Harry Blackmun, who refused to have dinner with people who might conceivably at some point in the future have a case before the Supreme Court, even if he was going to pay for dinner. He refused to sit down with someone privately who might have a case before the Supreme Court. And we made fun of him a little bit, I have to admit, as law clerks do, behind the back sometimes of their justices. But even if he were somewhat more lax, I think the standards overall have been reduced for the conduct of Supreme Court justices. At the time, Justice Douglas was regarded as an outlier because he wrote books. He wrote books. Supreme Court justices don't write books. Of course, every Supreme Court justice now writes books. So I think that we're dealing here with a cultural change that has really contributed to diminishing respect for the Supreme Court. And, to answer a little bit more the question that Chairman Durbin asked of Mr. Sample, Professor Sample, the Supreme Court has a mystique. You may regard it as a mystique, not justified in fact, but it is a credibility, a trust, confidence that is so necessary for a court composed of 9 people, unelected, presiding for life, and able to strike down the will of a democratically elected Congress. It's extraordinary in a democracy. And so I am really just baffled by Chief Justice Roberts, because he should know better. And this controversy could be diffused if he were willing to lead. And obviously we've asked him to lead again and again and again. But the failure to take the reins here, which could easily supplant these kinds of measures if he were to voluntarily impose some code of ethics, and there would be enforcement questions, but at least there would be a code of ethics and the Judicial Conference or someone could enforce it. I don't want to be unfair to any particular justice, because I recognize that these questions can be asked of any or all of them, but thinking to Justice Thomas's presiding over questions relating to January 6th in light of his spouse's text messages to then White House Chief of Staff Mark Meadows regarding theories of fraud in the 2020 election and strategies to overturn the election, and his insistence on refusing to recuse himself on matters related to January 6th seems to me to flout Section 455 statutory requirements. That's a statute that exists. No one should be above the law. We all agree. So I think that's a reason for the diminishing public confidence in our Supreme Court at this historic time and a historic low. I have unfortunately, just about exhausted my time. But let me ask you, Ms. Mascott, without asking you to comment on Justice Thomas, isn't there some way for this body, in the absence of leadership from the Supreme Court itself, to insist that some standards be imposed? I understand fully your argument about separation of powers, but where no decisional outcome, where no substantive issue is determined, isn't there a way for us to act?
Well, I mean, certainly I think through this hearing and through the policies that have been put in place regulating the lower courts, this body has made clear standards that it thinks should apply to recusal. And it sounds as though, I think from the chief's statement that he provided prior to the last hearing, that the Supreme Court justices are aware of concerns and are going to continue to be careful, as they have been, in trying to police and make their own decisions and be faithful to make sure that they're recusing in cases where they have involvement. I mean, another very real procedure that we haven't discussed a lot today, but I think has appropriate constraints and obviously political costs for this body, which is why it's not more used. But I mean, the Constitution, of course, does have, for wrongdoing and investigation, always has the impeachment authority. And so I guess some of the concerns, I think, coming into play here are when this body decides to not use that more serious structure, whether there are concerns in a body of 9 decision makers, as you all say, with too readily insisting that one of those decision makers recuse and not participate in exercising the judicial power when we don't have evidence of wrongdoing and we don't have reason to believe that the process is actually not working.
My time has expired. I hope maybe we'll have a second round.
Senator Padilla has arrived, and by vaunted Senate principles of seniority, he is next, followed by Senator Welch.
Thank you, Mr. Chair. As has been discussed at this hearing, and I apologize for arriving late, you know how it is, multiple votes in multiple committees. It's clear that the current law governing recusal gives judges and justices a lot of discretion when making recusal decisions. And there have been numerous instances of judges abusing this discretion, from district court and circuit court judges failing to recuse themselves from cases in which they have a financial interest, to Justice Thomas failing to recuse himself from cases concerning January 6th, despite his wife's documented engagement with the organizers of the insurrection. So the legislation we're discussing today would begin to fill those gaps by laying out specific instances in which a judge or justice must recuse themselves, including instances where a party has given a gift or made a financial contribution to a campaign supporting a justice's confirmation. Mr. Sherman, I'll ask you, why are these specific recusal provisions necessary, and are there any other specific provisions that Congress should consider?
Well, I think they're necessary because, as the last several years have demonstrated, again, activists and advocates who want to influence the court will exploit every loophole possible, which is quite easy when there is no binding code of conduct for the Supreme Court to abide by. I think the CERT Act would address a lot of these concerns by not only providing transparency, additional transparency with respect to the justices' financial entanglements and creating a duty to know across the federal judiciary, but it would also provide transparency with respect to amici who are seeking to influence the court, and then ultimately, as you said, provide an independent and transparent process to adjudicate recusals, which I think is where the public has really grown frustrated and quite concerned about justices and judges ruling on cases in which they have a financial interest or a conflict of interest or other conflict of interest.
Thank you. And there's certainly skeptics out there who have expressed concern that the more stringent judicial recusal requirements that we seek to put in place, along with public explanations for recusal decisions, would actually invite gamesmanship at the Supreme Court because there's only 9 justices. Again, the legislation we're talking about would reduce, I believe, would reduce opportunities for such gamesmanship by providing clear-cut guidelines for when a conflict of interest requires recusal, taking the guesswork out of the process. Now, federal judges want to hold themselves to a high ethical standard. They claim that they hold themselves to a high ethical standard. Our legislation would make it easier for them to do that and for the public to see that. Question for Professor Sample. Can you explain how clear guidelines for when recusal is called for would lead to greater consistency and transparency in recusal decisions?
Yes, Senator. I think most prominently, eliminating the judge as judge in his or her own case is an important preliminary step. And at the Supreme Court level, while yes, in theory, there is a gamesmanship concern, I think it's worth noting that the justices regularly decide cases on issues of major national import all the time, and they often disagree vehemently and still maintain a good working relationship. So I don't think that the individual justices out there would be looking to game the system by recusing their fellow justices or voting unless those recusals were truly warranted. And I think if they are truly warranted, then the entire nation is served by those recusals. We've had situations, I mean, we went over a year with only 8 justices on the bench because Congress refused to give Merrick Garland a hearing. The court managed to function with only 8 justices for more than a year. I think they can manage to function with only 8 justices in one particular case.
Excellent point, and I'm glad that in the reporting from this hearing, that quote will be attributed to you and not a member of the committee. Thank you very much. Thank you, Mr. Chair.
The patient, Senator Welch.
Thank you very much. In response to a question I think Senator Durbin asked Professor Mascott, you used the term impeachment. Are you serious? What are you talking about? We should be impeaching judges? What did you mean by that?
Oh, no, what I was saying is that the Constitution, like it does in many instances, has very challenging, finely grained procedures in place.
I understand that, but we're talking about a very concrete situation about a failure to report reports of a justice having been the beneficiary of very expensive travel arrangements. So I just don't know where that word came from and what you're suggesting.
Well, I guess what I'm suggesting is that there were questions being raised about congressional regulation and investigation of alleged wrongdoing or concerns. And so what I was saying, which I would say if we were talking about the executive branch or
time, but here's what it sounds like you're saying to me. We don't have the power legislatively to require ethical disclosure, but we do have the power to impeach. Isn't that a little overkill?
Specifically what I said in my opening statement is that the particular aspects of the bill that I think create the most constitutional tension are the ones that allow members of the public and members of lower courts to adjudicate decisions by Supreme Court justices.
Let's talk, you're talking constitutional tension. How about public credibility? I'm of the view that constitutional protections are one thing, norms are another, and if there's not credibility among the public for the institutions that are here to serve it, Congress, Supreme Court, the presidency, then things fall apart.
I share with you concerns about, and I think across the board, federal institutions are struggling with credibility, and unfortunately, I think Congress's approval rating is lower. Sorry?
Do you think that the 9 people who occupy the highest judicial positions in the country can maintain credibility with the people they serve? And by the way, they're public servants too. They're not above the service requirement? Do you think they can maintain credibility with the public, or even deserve to, if they won't disclose when they are the beneficiary of extraordinarily generous and completely out of reach vacations that only they can get by virtue of the position they hold?
I mean, in contrast to a lot of my, colleagues, academic and otherwise, I actually think all 9 justices admirably are trying to apply the rule of law in every case according to the constitutional
in one case,
theory
they
that
didn't
they
do
believe.
it. If these press reports are to be believed and no one's challenged them.
Well, no, no one has made an accusation. Actually, I don't think that the disclosure requirements or anything about them has been related to any decision in a case. So I think that's another point of connection that should be highlighted.
So if you got thousands of dollars in vacation benefits, but you weren't pending before the court, you don't think that's going to raise public questions? All right.
I
think I see where you're coming from. I guess I'll respectfully disagree. I am extremely worried about what's happening on the Supreme Court and what's happening with the failure of the Chief Justice to do what would relieve us of this public spectacle. I'm worried because the Supreme Court has to be a credible institution in our democracy. And I'm worried about how that's eroded with the unwillingness of that court to subject itself to the same ethical requirements that 850 other federal judges adhere to. I'm worried about what has happened with the credibility of the court because of the spectacle of Supreme Court hearings here and the unwillingness at one point of allowing a duly elected president from having his nominee considered. And on this question of separation of powers, I'm worried about judicial abuse of legislative power by refusing to uphold a bipartisan campaign finance law sponsored by John McCain, among others, Russ Feingold, that was intended to restore credibility to the election process. Those are my concerns. Congress has a role to play. The court has a role to play with its ethics, and the court has a role to play with respecting the right of the majority to legislate decisions on behalf of the public interest. I yield back.
Thank you. I'm going to ask an extra question of Professor Sample and an extra question of Professor Sherman. With respect to Professor Sample, the new statement on ethics principles and practices that the justices put forward posits a duty to sit. Explain to me why it is preferable to have a conflicted justice sit on a case than to have the conflicted justice recuse.
Senator, I think the statement on the duty to sit is respectfully overstated, which is to say that we have lots of empirical evidence, and we were referencing some of that empirical evidence earlier. A recent Bloomberg study indicated that justices recuse from approximately 3% of the cases. So the duty to sit is not trumping basic recusal requirements in those cases. We've explored the fact that we went more than a year with only 8 justices on the court, and the very same individuals who are now championing this extraordinarily robust version of the duty to sit didn't seem to have a problem with the court sitting with only 8 justices. I do not think that the duty to sit argument holds water when measured against the importance, the fundamental due process interest in an impartial judiciary.
And Mr. Sherman, let me offer you another hypothetical that appears to be actually the fact right now. We have a justice on the Supreme Court who has written a book from which that justice receives royalties that go directly to the benefit of that justice. A firm is helping that justice sell that book as agent and PR operation. It appears to be the only book that that firm supports in that way. And that firm, CRC Advisors, is run by the same Leonard Leo, who was responsible for orchestrating so-called Federalist Society lists, which the Federalist Society has disavowed, for running the ad campaigns behind the confirmations of the 3 Trump appointees, and whose network of front groups persistently files briefs before the Supreme Court without disclosing any of those links. Setting aside all those links not being disclosed, what are the problems with the ability of somebody in that position to drive royalties into a justice's pocket by organizing massive purchases, perhaps even bulk purchases, who knows? And why should there not be disclosure of these contractual relationships when cases come up in terms of looking at recusal?
There absolutely should be disclosure in the situation that you described with respect to amici or parties who are effectively have the ability to funnel money to a justice. And again, without casting aspersions on the nature or the motivation of the relationship, the nature of it demands disclosure. And it also demands an independent recusal process. And, you know, I think if the CERT Act is passed, one of the things that will happen if the justices have to sit in judgment of each other is that there will be a chilling effect on the kind of conduct that we have seen over the last few years, because the justices, not only do they not want to sit in judgment of each other, they don't want to force their colleagues to sit in judgment of them. The reason why right now the court is operating with carte blanche is because every justice has the individual decision to decide on whether they should recuse or not, and they don't have to disclose it at all. And if I may, I would just add one thing about the duty to sit, which I also found incredibly problematic and frankly arrogant. I would say that if the justices were serious about this duty to sit, then they would, of their own accord, enact significant prophylactic measures to eliminate conflicts before they arise. That could take the form of many different things, including banning the ownership or sale of stocks by themselves or their families. It could manifest itself in prophylactically deciding to ban certain types of travel. Again, the duty to sit is important, but if the justices were serious about their duty to sit, then they would take significant measures to avoid conflicts in the first place. What the court is saying in this 2 or 3 word statement is that they feel empowered to sit despite a conflict rather than a duty given their roles to eliminate conflicts in the first place.
Thank you very much. This has been a very helpful hearing. I'm very grateful to all of the witnesses for attending. I appreciate it very much. In closing, I'd note that in terms of, peers sitting in judgment of one another, that's what we do in the Senate. That's what the Senate Ethics Committee does. It requires peers who serve on the Senate Ethics Committee to sit in judgment of other senators who've gotten in trouble. And one of the ways in which you make that real is by having talented staff and staff attorneys who go through the process of finding out what the facts are so that a proper decision can be made by the peers against or as to each other's conduct. And in the case of the Supreme Court, not only do you not have the peer review, if you will, you don't even have the most elementary fact finding. There is not a court in the country in my estimation, where if a recusal issue was properly raised, there would be no way to determine what the facts actually were as to whether a justice or a judge should recuse or not. It simply doesn't happen anywhere else. And the idea that the court, setting aside being unwilling to sit in judgment of itself, is unwilling to even have facts found about itself is so out of kilter with basic premises of due process and proper procedure and American rule of law that it's a little bit astounding to me. And the fact that we just don't ever get a proper, honest answer about even the facts, setting aside what you then do with them, is a little bit stunning. And I'd also note in closing that there's a perfectly good financial disclosure committee that sits within the Judicial Conference. And if the justices have questions about whether their conduct might violate the ethics rules, they've got an all-judicial place to go where other judges would give them advice and let them know, whoops, no, you shouldn't do that. No, you should probably have disclosed that. So when we're evaluating a justice's determination to rely on what he, I believe, called informal opinions of colleagues and others, that justice was bypassing the actual judicial system through which any federal judge can get an advance, private decision about what they need to disclose. And I think one of the reasons that so many other federal judges are so furious about where the Supreme Court now is that they live within those rules. They file their questions with the Code of Conduct Committee. They file their questions with the Financial Disclosure Committee. They abide by the results that they get. They don't have a hallway conversation with a colleague about an ethics issue and then end up taking a position that is virtually indefensible. And so there are many, many ways in which this can be resolved. I just want to say that I, for one, and I think most of my Senate colleagues, at least on the Democratic side so far, as we've heard today, are going to persist at this. We are in an intolerable and indefensible situation. And if the court itself or the Judicial Conference, acting as the overseer of the administrative aspect of the judicial branch, which this falls into, won't act, then it leaves it to us to act. Because the worst case scenario is a court whose credibility is in free fall because it won't hold itself to standards that every other federal judge knows are proper. Thank you very much. If anybody has, I don't know if there were any questions for the record. Nope. Well, if there are any questions for the record, they've got to be in by tomorrow? A week. Oh, we got a whole week here. In budget, we're much tougher. You got a week. If anybody has questions for the record to ask the witnesses, if we get those questions, we will pass the questions to you. We hope that we can get rapid responses back to those questions. I appreciate very much the dialogue that we've had today. I appreciate very much all of you being here. And with that, hearing is concluded.